The court sat in Accra, away from its seat in Abuja, Nigeria, in an effort to demystify its works and to bring its services closer to the community citizens of ECOWAS. It heard cases involving the republics of Ghana, Nigeria, Togo, and the ECOWAS Authority of Heads of States and Governments and the ECOWAS Commission. President of the court, Honorable Justice Edward Amuakwa Asante, announced that the Accra external session recorded a new feat.
The importance of the session cannot be overemphasized, particularly in the context of the court's judicial diplomacy, as it affords it the opportunity to engage with the national courts of member states, as our collaboration is imperative in order to achieve the full intent of the integration process. This is particularly important because the ECOWAS court relies on the national courts for the enforcement of its judgments. Therefore, both courts represent the cornerstone of the community legal order as they create the enabling legal environment for the attainment of the objectives of the community. During the 2 weeks of sitting in Accra, the court set a new record in its history by delivering 20 judgments, the highest number of judgments delivered in a single external court session.
While encouraging governments to allow community citizens an unimpeded access to the ECOWAS court, Justice Asante laments the low compliance rate with its orders.
The court remains concerned about the low level of enforcement of its decisions, which remains at about 30%. Article 24.3 of the Supplementary Protocol on the Court provides that each member state shall appoint a national authority for the purpose of reception and processing for the execution of the judgments. And only 6 member states have complied with this. That poses a challenge to the enforcement of the judgments of the court.
Kwesi Enin-Yeboah, Chief Justice of the Republic of Ghana, admonishes the court in his closing remarks not to position itself in direct conflict with the national courts of member states.
Through these sessions in cities around West Africa, more and more of the citizens will become aware of the court's activities. And with that, the court's mandate will be strengthened and public trust increased. Over the last 10 days, we've had the privilege of hosting the court as it heard some 60 cases and delivered judgment in some of those cases. We in Ghana are proud to be associated with the ongoing strengthening of the courts. It is our hope that these historic sessions will become important bookmarks in the history of the court. As we look to the future, let us all remind ourselves of the ideas and proposals that have been tabled during the sessions.
At a post-session press conference, however, President of the court explained the position of the court within the ECOWAS protocols.
In 2005, there was a defining shift in its mandate following the adoption of the supplementary protocol, which amended the initial protocol on the court. The said supplementary protocol expanded the judicial mandate of the court and virtually transformed its mandate into 4 as follows. A mandate as a community court, which involves the interpretation and application of the ECOWAS community text and giving advisory opinions. Mandate as a public servant court, which gives the court competence to adjudicate on any dispute between the community institutions and its officials. Mandate as a human rights court, which gives the court jurisdiction to determine cases of violation of human rights that occur in any member state. The unique feature of this jurisdiction is that there is no requirement for the exhaustion of local remedies. Mandate as arbitration, the tribunal, which gives the court the power to act as arbiters pending the establishment of the arbitration tribunal under Article 16 of the revised treaty.
Notwithstanding the low compliance rates with its orders, the ECOWAS Community Court of Justice seem to be very worried about the fact that there are not many cases bordering on regional integration, on fostering trade relations, and on ensuring that member states relate with one another as community citizens. Reporting from the external community court session here in Accra, I am Sixtus Dong Ulum for Citi News.